So for those of you that belong to our newsletter, the Nebraska Landlords and Managers newsletter, you're quite familiar with all the different legislative bills that we've been putting forward the last couple of weeks. There's about a dozen of them that's been introduced by state senators, and they impact the landlording and the management community directly. But for those of you that may not know what's going on. So that's the reason for this particular video. So starting today and every day until I'm done, I'm going to be doing a video on all the different legislative bills that have been introduced by state senators here in Nebraska. The first one I want to talk about is Legislative Bill 17. This has been introduced by State Senator Kavanaugh. This would restrict or basically prohibit fee-based management or fee-based landlording, which is very popular right now, particularly in the management community. As there's pressures on rents, then we implement these fees. Fee maximization is kind of like the subject of every single property management convention that you go to. Fee maximization. And in the state of Nebraska, if this passes, it's done. We won't be able to do that. So I want to talk about the particulars of this bill here. So the first thing is there's only 5 authorized monetary items that you could collect or charge for if LB 17 passes. Number 1 is rent. Number 2 is security deposits. Number 3, late fees would be allowed, but late fees would be capped at 5% of the amount that's owed or $50, whichever is less. And then the last one would be application fees. We could still collect an application fee or charge one, but it would be restricted to the actual cost of whatever report you're obtaining. So if you're going out and you're collecting or getting, you're being charged by Tenant data services, $25 for the background check and the credit check. The most you could charge the tenant is $25. It is very common in our industry to upcharge that a little bit because we do have extra time in processing their applications outside of the credit and the background check. Things like getting references from previous landlords, etc. So we're kind of offsetting that staff cost or our time by upcharging that application fee. If LB 17 passes, that would be it. We wouldn't be able to do that anymore. All right, the other thing, some of the different rules that we would have to abide by. Number 1 is we could not deposit an application fee, whether it's cash, check, credit card, or whatever, until we actually run the report. Right now, we don't do that. Most of the time, it's for efficiency's sake. We just deposit everything during our daily deposits, and then we run the reports. We wouldn't be able to do that anymore. We would have to do it as we make those applications, as we process those applications. The other thing is that we would have to do is provide a credit report or an adverse action report to every tenant automatically. I think that this part of the provision or LB 17 may run into some Fair Credit Reporting Act challenges. However, I think what would happen is because the law requires us to do it as it's written, I think probably most of the screening companies would just do it automatically where we wouldn't have to do it. It's already set up that way right now, where when we send an adverse action report out to the tenant, we have to provide the name of the screening company, the address, and then instructions on how the tenant can contact that reporting company to obtain a free credit report, for example. Now it would be automatic. So I think what will happen in this case is those screening providers would do it automatically to remove us from that process. The other thing we would have to do is in our denial letter or our adverse action reports, we're going to have to provide within 20 days a detailed description of why we denied the application. Specific reasons. Now, this is totally contrary to what we do today, and mostly because of liability risks, right? So what we're going to do in today's world or current process is we're going to send an adverse action report that vaguely says that based on credit information that we've obtained in the credit report, we can't rent to you. And then here is the credit reporting agency, the information on how to contact them, etc. That's how it's done today. We would actually have to provide more detail, specific reasons why. So for example, many of us rely on those previous manager landlord references for our current applicants. We call them and say, how were they? And then we get feedback and we make a determination based on that feedback whether we're going to rent to them. That particular part, I think, would go away. We would have to then provide all the detailed description of that landlord reference to that current applicant. That increases the liability on those previous landlords and managers substantially. We run the risk of being sued for defamation and libel. We're going to have a lot more documentation because we're going to have to substantiate those references that we give. What I do think would happen if LB 17 passes, I know what I would do. In the management company, we would just provide no more previous landlord recommendations whatsoever. That would be the safest bet. I mean, that is kind of an industry standard in some parts of the country, but it would become in the state of Nebraska, I think, not only in the management world, but in the landlording world, just standard operating procedures. So that's a big change. That's a big thing that we would have to take into consideration. Another thing. So we would have to disclose the total cost that the tenant's going to have to pay every month. And I actually agree with this. And if the disclosure of the actual cost to the tenant on a monthly basis was the only thing in this bill, I would actually support it. And I got to be honest with you guys. This is a problem in our industry, at least in Nebraska. I get a call almost daily from tenants saying, I thought my rent was $1,000 a month, and now it's $1,250. There was $250 of add-on cost and fees and all that stuff. The ad only said it was $1,000 a month. No one told me I signed the lease. Now they want $1,250 and I'm stuck. That's a problem in our industry. I hear it every day. And it's not right. If you're going to charge $1,000 a month for rent and then you're going to have $250 in monthly fees, pet fees, and all of that stuff, you really need to let the tenant know morally, ethically, and every other way that, hey, here's what your total cost per month is going to be. If this passes, we're going to have to do that ahead of time so the tenant knows before they sign the lease. And my guess is we'll have to document it and have the tenant sign before the lease is signed. These are just some of the things that are in here that we're going to have to deal with. Again, I actually support that particular part of it because it is an issue in our industry in Nebraska. However, I think maybe one of the biggest issues we're going to have to deal with is how we process our applications. So the way that we should be doing it under fair housing is first come, first serve. I know a lot of landlords out there, they like to pool the applications. So that if they have 10 applications, they will run all the credit checks and background checks of all the 10 applicants and then pick the ones that is the best. You really can't do that. When you do that, you're at substantial fair housing jeopardy. The way it really should be is you date and time stamp when you receive the application. So if you have 10 applications, you're going to process those in the order that you received them. So let's say that applicant number 1 and 2 are disqualified. You send your adverse action report off and you're good. Applicant number 3, they are qualified. You notify them that they are, they're qualified. And if you want the property, let us know. But we also know that many times after we notify the tenant that they're approved, they never show up. You never hear back from them again. If LB 17 passes, you would not be able to move on with applicant number 4 until applicant number 3 has either told you that they are accepting the property or rejecting it and they're not going to move in. That's basically what's going to happen. So that's going to really slow down this process if LB 17 passes. If it does pass, one of the things I think we're going to have to do is put something in the application process that's where the tenant is acknowledging that if they are approved for the apartment or the house, they have 24 hours to let you know. Otherwise, failure to notify you one way or another is deemed to be a denial, they don't want the property so we can move on. Because otherwise, we may never hear from them. So that's one of the unintended consequences of LB 17 if it passes. And quite frankly, between the monetary restrictions on fees and then the process for, running your applicant's application, this is a very substantial legislative bill that's being proposed. So that's one of the reasons why I'm letting you know, so then you can come out, you can notify your state senator of your position on this. So, all right, that's all I got for today's video. If you have any questions, any comments, down below in the comments section is really important. And don't forget, if you're not currently a subscriber to the Nebraska Landlord and Manager newsletter, please do so. Go to nebraskalandlord.com, put in your email address, and you're going to get weekly updates on all of this and a whole bunch more as well. I'll see you in the next video.